Who is always trying to get the content of this to a third party? Please, the person should stop. You don't have our permission to do that. Okay, so we will start in another 5 minutes when the number of the participants in the class has increased. Still at 29. What's going on today?
have exchanged.
Hello. Okay, we can start now. Good afternoon, everyone. Good afternoon. Okay, I'm just going to go over the the class captain. I'm already in class, so please cut off your call. So bottom line of it is that last week, I believe on Thursday, I thought I was giving a lecture to the class while on the road, but it turned out I was talking to myself. So I'm just going to start with what I tried to discuss and go to the topic which I wanted to deal with today. So today we will be looking at constitution making. We have defined the constitution as an instrument that is fundamental in any society. It establishes the organs of government. It delineates the relationship between the government and the people, and also recognizes the rights of the people, which must not be violated, and is normally guaranteed in the Constitution. The Constitution can also go forward to express the territorial sovereignty and also the sovereignty that is in the states and the relationship of the sovereignty and the government and how the powers are to be exercised. Having said this, in most cases, we look at how did the Constitution come about? So I've sent some materials to you. We'll be using the first one especially, which look at the constitutional history of Nigeria and constitution making. Now, from 1914 to 1960, clearly we had a colonial system of government. And this colonial system of government started with the 1914 Constitution. We had the 1922 Constitution, the 1946 Constitution, 1951 Constitution, and the 1954 Constitution. As these constitutions are known by the names of the protagonists, the governors who seek to bring about constitutional amendment, it has been said that these constitutions were colonial constitutions. And as such, the process by which they came about did not give adequate attention to the people it's governing. Although the 1951 Constitution, it's one exception to this assertion, because the 1951 Constitution involved widespread consultation. And Professor Abiola Ojo, in his book, Constitutional Law and Military Rule, went in depth in the analysis of the 1951 Constitution and suggested that the 1951 Constitution had wide consultation to have qualified to be classified as an autochthonous constitution, if not for the fact that it's a product of colonial, administration, to which the people were not, could not hold accountable. So sovereignty and the influence was foreign. So in the final analysis, it is said to be a constitution that is made by a foreign authority and a foreign power. So the focus of the constitution making in line with meeting the aspiration of the people is assessed in relation to the 1960 Constitution, 1963 Constitution. The 1960 Constitution was a product of constitutional conferences from 1954, 1957, and then we had the 1960 Constitution. In fact, we had 1959 Constitutional, London Constitutional Conferences. Now, these constitutional conferences had in attendance representatives of indigenous political parties. These were the negotiations that took place as to how the regions, the three regions, in fact, we went from one region to three regions from 1946. And in 1954, in fact, the Eastern and Western regions wanted independence because the government of Ghana by 1957 had gained independence. In March 1957, on March 3rd, 1957, Ghana became independent. And so that led to agitation for the independence of Nigeria. Excuse me. However, the northern region was not ready. So in 1954, there was more, regional autonomy that was given in the 1954 Constitution. And from 1954, the constitutional conferences were held to negotiate and look at the framework for the independence. And of course, that led to the Independence Constitution of 1960. The Independence Constitution definitely did not have the requisite constitution-making processes that involved the people of Nigeria. So, for instance, there was no referendum, there was no plebiscite, there was no constitutional constituent assembly. There were just constitutional conferences of political parties. And as a result, the 1960 Constitution is said not to be autochthonous. Now, the 1963 Constitution, on the other hand, had, a conference that was done for purposes of reacting to some of the decisions that were made by the Judicial Committee of the Privy Council, JCPC. And as a result of it, there was a coming together of the political parties. And this has been said to be a constitution made by the people, because most of the people involved in this constitution were Nigerians. And as a result of that, it has been said that the constitution-making process was representative enough. However, when you look at the we the people that is contained in most of those constitutions, there was no sufficient involvement of the people for there to be an assessment to say that the Constitution is the Constitution made by the people. Then we had the military regime. Of course, military constitutions, we can't say that there was any constitution making. It's just a decree promulgated by the military from 1966 up to 1979. Now, the 1979 Constitution was very involving. For a preliminary, preparation for the making of the Constitution, there was a Constitution Drafting Committee. This Constitution Drafting Committee also invited, political debates. And in fact, these political debates was collated in the form of publications in media and all that, in a book that was authored by Professor Ojo, Walter Afonagoro, and Dele Giwa. And this book, itemized the subject matters that were, necessary for the crafting of the Constitution. This was subsequently followed by the Constituent Assembly of 1978. And that Constituent Assembly now invited, what you call memoranda from all segments of the society. The Constituent Assembly was not constituted by a wholly democratic process, because even though there were people who were nominated and representative of the various sections of the society, however, there were more appointed people from government than the representative people. So the lopsidedness in favor of appointed people have made the Constituent Assembly to be criticized. Now, what the Constituent Assembly did was to look at the Constitution Drafting Committee products and to give Nigeria a constitution. And the Constituent Assembly now purportedly enacted the Constitution into law. Unfortunately, the Supreme Military Council and the Armed Forces Ruling Council now ignored that enactment into law promulgated the Constitution into law and put in provisions that were never debated by the Constituent Assembly. For instance, he made NYSC part of the Constitution. He made Land Use Act as part of the Constitution, and several other provisions that were not debated by the Constituent Assembly. So this had been criticized, that it took away the process of we the people, the constituent power of the people in the Constituent Assembly, just like the Indian Constitution of 1949. And as a result of that, this constitution has been wholly, criticized as failing in living up to the autochthonous nature of constitution making, which impacts the assertion of the claim of the Constitution as a product of the will of the people. In the preamble, we, the people of Nigeria, hereby make unto ourselves and all that. So the 1979 Constitution was also, has been criticized. Although, when we finish, I'll give you the principle when it comes to autochthony, when they say substantiality. If we look at the process, we can say that actually the 1979 Constitution has been the most autochthonous constitution with respect to that terminology or that claim. Then we have the 1989 Constitution that was, aborted. And then we have the 1995 Constitution that never even came into anything. Then we have the 1999 Constitution that came as a result of a political debate conference chaired by Justice Nikki Tobey. And then subsequently, a small group of drafters were put together to do what they call the necessary amendment of the 1999 Constitution. Interestingly, both the 1979 and 1999 Constitution were promulgated into force by a decree of the military. In fact, it was promulgated by a decree of the Armed Forces Ruling Council. And, that has led to criticism of the 1999 Constitution. Now, when we talk about the constitution making, there are certain principles that surrounds the constitution making. One is the issue of autochthony. When you talk about autochthony, for a constitution to be autochthonous, the constitution making process must be involving of the people. So the constitution must be able to qualify as a homegrown constitution. What we mean by homegrown is that the people to whom the constitution is made are involved in the constitution making. They have a voice in what gets finally, and they are the ones that promulgate the constitution into force by the sovereign authority of the people. But when you look at the 1979 and 1999 Constitution, yes, the 1979 Constitution, there was consultation, there was constitution drafting, there was Constituent Assembly, but in the promulgation of the Constitution by decree, several provisions were, imported into that Constitution that affected the claim of autochthony. In fact, the Patriots, there's a group called Patriots made up of Nwabweze, F.R.A. Williams, and the likes of them, who said that the 1999 Constitution is an instrument that lies against itself, in the sense that the first statement of the Constitution that we, the people of Nigeria, make this Constitution and all that, it's a lie. Because there was never a time, there was no Constituent Assembly, there was no Sovereign National Conference, there was just a political debate, and this, they say, does not amount. Now, that has also been contested by Professor Taiwo Shipito and the likes of them, who says that, look, if you look at the procedure by which the Constitution was made, it was made by Nigerians. There was no foreign authority, even the decree they are talking about was made by Nigerians. And unlike the 1979 Constitution, there was no imposition. There were just necessary amendment that was made, and there was no imposition of any constitutional provisions by the military. So to that extent, it qualifies. And the formal aspect of we the people is a drafting, style that tends to impart autochthony to the Constitution by saying we the people made the Constitution. Then there is another claim that, look, the Constitution did not conform to the new method of making Constitution that looks like transparency, accountability, inclusivity, involvement of gender, and all that. So to that extent, when you look at the Constitution-making process in Nigeria, none of them has passed the pure, requirement of autochthony. But like I said, the substantiality principle says that, look, autochthony is a theory. You don't need 100% autochthony. But if there's substantial involvement of the people in it, then the Constitution is impacted with, autochthony. Now, why do we look at the Constitution-making process? We look at the Constitution-making process because the process, like I said, in jurisprudence, there is the historical school, which says that any law that wants to have effectiveness must be a law that derives from the will of the people, which is called vox gest. That is the will of the people. And that is why when we are looking at the Constitution, we are looking whether it is reflective of the will of the people. If a law is derivable from the will of the people will obey the law. The people will revere the law. The law will be effective. The law will achieve the purpose for which, So when you look at legitimacy, effectiveness, and, the reverence of the people to the 1999 Constitution, it's not there. And that is why there's been...
Wait.
Hello, Damilola, we can hear you. And that is why there is a call for a sovereign national conference, or what we also call restructuring, because it is felt that, look, the people of Nigeria have not sat down to give to themselves these constitutions. And as a result of that, these constitutions do not derive from the people. And that is why people don't have that much of a respect for the 1999 Constitution. So these claims will continue until probably the Constitution will be amended. But there is another school of thought that says that, look, the Constitution may be amended to cure the defect without a sovereign national conference. And that is a school of thought that obtains that, look, once the Constitution comes into operation, legitimacy is conferred on it by the people, by its observance. Effectiveness is conferred on it by the necessary amendments that is being made to the Constitution. And that is why the 1999 Constitution has been amended. There is a First Amendment, Second Amendment, Third Amendment, Fourth Amendment. And for as long as those amendments continue, they will continue to address the defects that are in the Constitution. And another school of thought is that, look, the Constitution is not just a legal instrument. It's a legal, political, social, economic instrument. So its legitimacy and effectiveness cannot only be tested on the legal ground. So if the Constitution is solving problem, people are respecting it, people are going about their business along with that Constitution, then people have accepted the Constitution socially, culturally, and it is also being tested in a court of law. So the issue of legitimacy and effectiveness is how the Constitution is operated. And that agitation will always continue because no Constitution is perfect. So Those are the arguments that have been made with respect to constitution making and autonomy and the new school or old school and all the arguments you find in the books. You find this, I think Professor Mowo's book is just a brief statement on constitution making, but the articles that I've given you, they have a thorough discussion of these principles. So I'll pause here for questions before I go to the next topic. Any question? Any observation? Yes, over to you.
Good afternoon, sir.
Mm-hmm.
Yes, sir. Please, sir, can you recap on the articles you said we should review?
Oh, I've already sent it to the class. So you should, the title, let me find the title of the article because I opened it.
Thank you, sir.
Okay, this is the one. Nigeria's constitution making experience since 1914, an evaluation. That's the article.
Thank you, sir.
I know you already have it.
Sir, good afternoon, sir.
Good afternoon.
Sir, do you think an autonomous constitution is achievable in Nigeria?
Well, when you have theory and you have practice, an absolute autonomous constitution may not be achieved. But, you know, a substantially compliant autonomous constitution can be achieved.
Okay, sir. Thank you.
Yeah.
Good afternoon, sir.
Good afternoon.
Okay, sorry. Sir, please, can you come again with the school of thought as to the nature of autonomy?
Okay, the school of thought on autonomy, I will repeat it, is a theory that evaluates the constitution making to determine the involvement of the people in the processes of its making. It looks at whether or not there was wide consultation, what level of representation do you have in the Constituent Assembly? What level of consultation did you have with the people? For instance, was there a referendum? Was there a plebiscite? Was there a certification? Was there an approval? Against that background, if you look at the South African Constitution, for instance, before it came into force, it has to go to the Constitutional Court for certification. And the Constitutional Court will look at the provisions and see whether or not they conform with the aspirations and goals and the intent of the Constitution. We don't have that. We never had any constitution with either certification, referendum, or plebiscite. At best, what you have had are consultations, conferences, debates. For instance, how many of you know that there's a constitution making process going on now with the National Assembly? You don't?
Yeah, we did not know.
There is one going on now. So that tells you that these things, we stopped it there for the pages of the Constitution. If not because I am, at least I think some people acknowledge me as an expert in this field, so they consult me. Unlike before, because I went to serve in the government, you know, once you serve in government, people see you that you are politically tainted. So to that extent, I don't get to have people who believe I'm in the opposing party to them consult me like before. But that also means that, look, the way in which people relate in this country, there's a problem with it. Because I served in my state doesn't make me a politician. So it took some people to say, Prof, we need your opinion on this. And I say, what are you doing? They say, oh, we are doing constitution amendments. The constitution amendment is not being advertised. It's just been done by the National Assembly. sectoral provision. So for instance, I got involved in the justice sector because the Attorney General reached out to me to be one of the consultants that was brought at the justice sector reform, conference. And then we look at it and all that. And of course, because I had taken some justice sector reform into, your state, and it became known that, this justice sector reform, it's Oyewa that is doing it and all that. But beyond that, it's something that all of us should be aware of. So in the end, when the Constitution comes out and you are looking at autochthony, that is the whole essence of saying that, look, are people actually involved in this, or is an elitist, process where the government and its people just go to the National Assembly and say, oh, we want this amendment, and they get it. Just like the government had said, oh, we want to change our national anthem, and they got it. So those are some of the time. That's why some people have refused today to sing the old and new national, because it's confusing. How did we go back to the old national anthem? And some words, and that national anthem was composed by an Oyibo lady, as opposed to the one that's composed by a Nigerian. So you find out that a lot of times the principle of constitution making and autochthony is to make sure that the products of the constitution has legitimacy, has effectiveness, and the buy-in of the people. They can say, oh, this constitution, it's our own. But bottom line of it is that the clamor for the amendment of the constitution will continue as long as issues are not addressed. And sometimes when issues are not addressed and they are left to fester, that's when you have IPOB, you have terrorism, you have all that. So
I have a question.
Okay, go ahead.
I say the 1999 constitution was made in the human way, but I didn't get
Can you come again? I can't hear you. Whether it's my...
The 1999 constitution was not made in the modern way. The modern way of making it as regards to
Yes. The 1999 79 constitution, it followed the old way of consultation and all that. The issue of inclusivity, if you look at the breakdown, how many people were young, how many people were women, how many people were special people, disabled people, there was no inclusivity, how many people were rural people and all that, So, whereas if you look at the process for the making of the 1989 constitution, it was so widespread in consultation and all that, but unfortunately that constitution was aborted. So the point you are making about accountability, inclusivity, the new way of making constitution, yes, those constitutions have not met it.
okay, thank you.
Yeah,
Thank you,
go ahead.
Good afternoon,
Yes.
sir.
Good afternoon, how are you?
I'm fine, sir. You spoke of autochthony as one of the processes of making constitution. I wanted to know, are there other processes involved?
No, please. Don't say what I didn't say. I spoke of autochthony as one of the theories for evaluation of constitution making. It's not a process.
Okay. I wanted to know, sir, what are those things that are really involved in during the process of making a constitution? Like, are there differences under a military regime and under a civilian rule?
They are totally different. In a civilian constitution making, we look at how the ideas, you are undergraduate. If you come to my LLM class, let me just vibrate a bit of advanced knowledge to you. There is what you call consensus building in constitution making. Have you ever heard that terminology? Consensus building.
No,
When
sir.
you want to make
Never.
constitution, consensus building is the beginning as to, okay, what should go into the constitution? What should be in chapter 1? What should be in chapter 2? What should be in chapter 3? Unfortunately, in Nigeria, that is what you see in the old new method, which you call inclusivity. In Nigeria, that consensus building is taken away from the people, is given to lawyers and political scientists to draft. So you have what we call a draft constitution. And it is lawyers and political science, who look at, oh, this there should be separation of powers. And in most cases, the constitution drafting borrows from, okay, let's look at American Constitution. It's not looking at the consensus building. Okay, so the thing you ask, if you want to make constitution, what is so important to the average ordinary person? The most important thing to the average ordinary person is not to be poor. It's not to be hungry. It's to be secure. It's to have access to good hospital, good something. You don't find this in constitution. So you find the basic common law approach. You have government, and then you now start electing people into governments, hoping that they will have that understanding. So, for instance, under the 1960-1963 Constitution, we borrowed the common law approach. And the common law approach puts value on the elected officials. So that's why we used to call elected officials men of timber and caliber, juggernauts and all that. We don't have those kinds of people again. So you are giving the same emphasis of power. You are giving emphasis to a president or a governor who is probably a cocaine pusher, who is a drunk and all that, who is a dancer. And it's a caricature of, it's a lack of understanding of constitutional principles and constitutional practice. So the consensus building for what goes into the constitution is not even there. So we start from the premise of let's draft a constitution. So we have issues like separation of powers, supremacy of the constitution. The question, are those the ones that get food to my table? And the underlying principle is that they ought to. And then we just bring in democratic governance. That, okay, if we bring in democratic governance, people should be able to vote in the right people. And there's also a fallacy there. You now have what we call election management body. And for emphasis, you put the name Independent National Electoral Commission. Putting independence in front of it doesn't make it independent. So there are some basic theories and concepts in constitution making. So in the consensus building, we can say, okay, we want to have a constitution that guarantees these rights to people. And those are some of the things that are the agitation and the criticism of our constitution. Because in the consensus building, what consensus are not in the constitution?
Question, sir.
They are there as fundamental objectives and directive principles of state policy.
Question, sir.
So when you look at constitution making, what goes into the constitution are one, the consensus building, then two, the structure of the government, the right guarantee to the people, the judiciary, the dispute resolution, accountability, transparency, and delivering the democratic, dividends to the people. And that's why they say, we have not had a debate on this. How do we manage our resources? Is it resource control? Is this resource management? Okay. So these are the things that goes into constitution making, the consideration. And then we now say, okay, for this to be present, let's look the principle of autonomy to gauge the involvement of the people. Are the people involved in this? Can we say that this constitution is the constitution of the people? Can we say it is homegrown and homemade? That's the theory of autochthony against the constitution making process. Yes, ask your question.
Yeah, sir, based on what you are saying now, and because I really enjoy your perception on this matter. Will it be right to say that are we having the right set of people who are making laws, both the legislative and both the House of Rep and the Senate for us? How knowledgeable are they? When you're talking about involvement and inclusivity, are they not supposed to be people who have legal minds? Because we're talking about legal process now and lawmaking. I just want to know your opinion on that, sir.
Well, I think you're asking the wrong question. The right question to ask is that how is the process of inclusivity in the way we elect people to represent us? Can you say, you as a person, can you say that the person in the House of Rep from your constituency is representative of the people in your place? You know, and that is what constitution making addresses. So we should be able to have constitutional provisions that will guarantee. And we don't, if the constitution, that's why the allegation or the assertion by the patriot that the constitution lies against itself, because the constitution has not addressed issues in constitution making. You can't have 1960, 1963, 1970, and then 1979 constitution, and then you have the 1999 constitution that is just a necessary amendment of the 1979 constitution. You know, if you say it's a necessary amendment, it is a necessary amendment. It's supposed to be a transient constitution, pending the institution of a process that will bring about the making of an autochthonous constitution. And that is the agitation and the argument for, you know, constitution making in Nigeria. I think you people are exciting me to visit this constitution making, to write upon it. And I think I probably will, because most times people don't understand why we talk about autochthony, why we want accountability, why we want inclusivity. It has a direct bearing on what the constitution would deliver. Yes, people will say, oh, American constitution is very light, it doesn't, but there are some underpinnings, there are undergirding principles. We don't have those undergirding principles, so we need to express ourselves in our constitution, you know? Any other question? Okay. In the absence of any other question, we'll continue to the last topic I'll be taking, which is constitutional interpretation. Constitutional interpretation.
Sorry, sir. In the last point, you were not able to take parliamentary and presidential constitution, and you said you would take it in today's class.
Oh, parliamentary and I did take a parliamentary and presidential.
You said, yeah, it was not very, and there were a lot of questions. So you said you would take it again and finish up classification of constitutions today.
Okay, let me just divert to that quickly. And you know, if you check the text we are using, Mowo's book, it dwelt on parliamentary and presidential. Now, when you look at the parliamentary and presidential system of government, what it's focusing on is the way the leadership of the government is produced. In a parliamentary system of government, the prime minister, who is the head of the government, is produced by elections that produces him in the legislature as a member of the legislature. And then from there, he being the majority leader of his party, he will form a government that will be approved once he has the necessary majority. And another aspect of it is that because he is coming out of the constituent representatives in the legislature, the legislature actually has the determination of the tenure of that government. And what it does is that the government, once there is a vote of no confidence, an election will be called. So its tenure is not as fixed as the presidential system of government. Now, on the contrary, if you look at the presidential system of government, the president is a product of the aggregation of all the constituent powers within the state. So the president runs on a wider national platform than the prime minister. And that's why the president campaigns, for election in all the, constituencies, as opposed to the prime minister that campaigns in his own constituency and wins and comes to form government. Secondly, the prime minister is recruited from the legislature. In the presidential system, there is no such thing. And that's why the prime minister is primus inter pares, first among equals. He is equal to everybody in the parliament, but is first among his equals. And that is why he's subjected to the question and answer session. Has any one of you watched the question and answer session for the prime minister?
Yes.
That's because that's the price he pays for being first among equals. His equals, they bring him and they can boo him, they can shout on him. And I think there's one going on between Badenoch and Starmer, which Badenoch was just, he was just terribly abusing the prime minister. And that's because they are equals. They are all members of the parliament. And there is always a session where the parliament, or the president, the prime minister goes to parliament to answer questions on live issues on national television. There's no hiding place for him. And if he continues to underperform before that, there will be a vote of no confidence and that Starmer will be out of office in no time. It happened to May. I think what's her first name? The prime minister, May. I don't think she lasted 6 months. I think she was there for 3 months, And so the give and take that you don't have it in the presidential system. In fact, in the presidential system, the president is not a member of the legislature. He cannot go to the legislature and sit down. He's normally invited, and normally he's invited to make a speech on the state of the nation or on the budget. His tenure is fixed. It's for 4 years, whether it's Baba goes slow or whatever. And it's a joke. Most times after election, 2 years down the line, 3 years, they start the thing all over again. So we are in 2023, 2024. By 2025 election campaign, those who want to president will start all over towards 2027. So the tenure is fixed and all that. And then we have what we call parliamentary presidentialism, where you have the president that is voted on a national something that functions in a parliamentary system of government. So that's what we have between presidential and parliamentary system of government. I think those are the things I stated. I don't know whether you have questions on that, and then we go to constitutional interpretation.
I have a question, sir.
Yes.
Under a presidential parliamentary system, who appoints the prime minister under the system?
Normally, the prime minister is appointed by a process that is produced in the parliament.
Okay, I was asking because when I checked out the France system, I realized that under the French system, it is the president who appoints the prime minister.
Yes, the president appoints him from the inside the parliament.
Yes, sir. And subject to the screening of the parliament.
Just like the Queen is the one that appoints the prime minister. Because the prime minister forms the government after the approval and assent of the Queen.
Mhm.
So the French system, the German system, and most parliamentary presidential system, there's the prime minister, but the president is the more powerful person than the prime minister. So that's why we call it parliamentary presidentialism.
Sir,
Yes, go ahead.
sir, I didn't understand the part that you were saying the prime minister is voted by his constituency.
Okay, in a parliamentary system, the prime minister, unlike the president, does not run on a national constituency. He runs on a constituency that is representative in parliament.
How are you?
Okay? So it is when he, even though he's known as the leader of the party, but he wins his constituency, and from there
Oh,
he's
is that your bread too long?
invited to form governments.
Is it too long?
David Badamasi, please mute yourself. And then iPhone 2, mute yourself because you are coming in with your talk. David Badamasi, mute yourself. iPhone 2, mute yourself. Okay? Hello, can you hear me now?
Yes, sir.
Okay. Are we clear? Can I go on? Okay, we look at constitutional interpretation. Now, in your legal system, you will learn what you call interpretation of statutes. The interpretation of statute has three basic rules: the literal rule, the mischief rule, and the golden rule. And interestingly, these principles of interpretation of statutes are similar to what is interpretation of the Constitution. There are certain basic things that are common to interpretation of Constitution. Normally, when you have a written Constitution, you need to have who is the final authority on the interpretation of the Constitution. And it is the apex court, the highest court, the Supreme Court. So this is a practice that we borrowed from the American Constitution, whereby the apex court develops concepts and theories based on, jurisprudence and all that, to say that, oh, this is the approach that we are using in the interpretation of the Constitution. I'm going to be giving your class an article written by me on interpretation of the Constitution. And one of the opening statements that I love is the statement by, let me see who made that statement before I just give you his first name now. I'll give you the whole name. Yeah, it's made by Honorable Justice Michael Kirby. Kirby is Kirby, who said that it is vital that each judge, indeed each reader of the Constitution, should have a theory of constitutional interpretation. Why? Only such a theory will afford a consistent guide to a consistent approach to be taken to the task. In the absence of the theory, inconsistency will proliferate. The judge will be castigated, perhaps correctly, for saying incompatible things at different times and construing the same words at different times in incompatible ways. This statement brings to mind the Nigerian Supreme Court. Because of the lack of a consistent theory of constitutional interpretation, either by the judges or by the courts, the court has consistently been castigated in constitutional interpretation. In fact, even when they give sound, pragmatic judgments, when people look at previous cases, they raise questions. In 2002, you said this. In 2003, you said this. Now, how come you are not consistent? The same you. In this case, you said this. In this case, you said. So, constitutional interpretation is to be a guide to the courts so that the court can be consistent. In the eyes of the people, the statement of the court made must be one that you can rely on. Why? Because one of the attributes of law is predictability. You should be able to say that, oh, this is how I can plan my life because the courts have said it, this is how it should be. But in Nigeria, a lot of times, different cases, different, particularly the Court of Appeal. And that's why some people believe that the Court of Appeal should not also be an apex court in election petition as it is now. Because the Court of Appeal is an apex court, the Supreme Court is an apex court, and both of them are apex courts giving contradictory decisions in the same election. So in the same election, the Court of Appeal will vacate some offices as it did in Plateau State. And the same election, the governor will go to the Supreme Court and the Court of Appeal judgment will be overturned. And because it's an apex court, its apex exercise of jurisdiction, even though found to be wrong, will still stand, even in the face of the decision of the Court of Supreme Court that invalidated. And those inconsistencies are because of the poor, adherence or the lack of adherence to constitutional interpretation theories and principles. That will be a guide that says, okay, when we are looking at this, shall is shall, may is may. Not that in one time you say shall means may, and then at another time may means shall, and then at another time, oh no. All those kinds of things opens up the judiciary to ridicule. And that is why the concept of constitutional interpretation is very, very important, in any jurisdiction. In the American jurisdictions, they have several constitutional interpretation theories that they adhere to in the interpretation of the Constitution. So you have several of such, interpretation being given by the courts. So the court has different schools of thought, theories of interpretation that they apply. You have such theories involving, the first theory in all of them is the literal rule. The literal school of interpretation looks at the interpretation based on the wordings of the Constitution. So where there is no ambiguity, where the word is capable of interpretation, you would think a word like shall will be capable of interpretation, though shall, of course, is supposed to be mandatory. But in some instances, the court will say, oh, within the context of the way the word is used, it's not mandatory, it's directory. That is just direct. If non-compliance of it is not, will not be fatal to, to the non-exercise or whatever. So bottom line of it is that words, when used in the Constitution, ideally they should be able to do, but sometimes words are used in ambiguous manner, so drafting is the culprit of such gaps, because if you have poor drafting, then excuse me, all this talking makes one to be a bit dehydrated in this Harmattan season, so permit me to drink. So when you look at the theories, the literal rule is there, the liberal approach, the literal rule, like I'll be looking at them one by one. The literal approach, the historical approach, the sociological approach, the cultural approach, the political approach, the economic approach. You can have all those theories. But under common law, Nigerian School of 1 minute. Hello, Femi, I'm having a lecture. I'll call you back. Okay, yeah. So you see that the approach that is being used by the US is based on the various theoretical and jurisprudential schools of thought. But what are the theories of interpretation that are used in Nigeria? Now, when you come to Nigeria, there are some fundamental rules, even though there are some sub-rules, even though the same way in the interpretation of statutes, there are the main rules, literal rule, mischief rule, and golden rule. But there are sub-rules of interpretation, like a use them generis, associate notious, and all that. Ololade, okay, you have muted yourself. So, but there are other principles that are there that the court will look at. So, for instance, effect will be given to every word. So you don't ignore some words. So you must read the words together. You can't just pick one word and say, oh, this is what it means. So you must look at the sentence, and then you must read the Constitution conjunctively, not disjunctively. You cannot say, oh, this means this in this chapter, it means that. No. You must read them together. Then a constitutional language of the Constitution, where clear and ambiguous must be, Then organic scheme. You should look at this Constitution and say, oh, what is the organic scheme? What is the whole idea of this Constitution? How can we read it together? So you find, for instance, in the case of Attorney General of Ondo State against Attorney General of the Federation, the court reading, Chapter 2 together with the exclusive legislative list in order to give effect to the ICPC Act. So you read the Constitution together. But what are the main principles for constitutional interpretation? The first one is the textual or literal approach. The textual or literal approach looks to the words. Once the words are unambiguous, they are clear in their meaning, and they are capable of giving effect to the purpose of the Constitution, then that is the approach to adopt. And literal approach is normally said to be the proper approach. And most lawyers start with the literal approach. They will say, oh, this word means this as a result of that, the text in itself. But where the text cannot be reconciled with the generality of the Constitution or other provisions of the Constitution, then the court will not stay with the textual approach. So the text must be very clear. And, in looking at the language of the Constitution, the court must be able to determine that, oh, this language is very clear, very, very clear. And once it's clear, that is what will be given to it. Oftentimes, the court uses the textual approach. A lot of times, the court uses textual approach. And once the text is very clear, the court will. But once the text is not clear, the court goes to what you call the liberal or broad approach. The liberal or broad approach is where the court gives liberal interpretation to words in order to fulfill the purpose of a particular provision. And I don't know whether you are familiar with the expression that words have what you call core meaning, they have general meaning, and they have nuanced meaning. And what we mean by core meaning, if I say water, okay, you know that I'm talking about this water that I'm drinking. That's water. But if I say, oh boy, water me now, what does that mean? If I say, let's test the class. If I say, oh boy, make you water me now.
Give me money.
Exactly. Give me money, give me food, do me well. Oh boy, water me, make I shine like you now. You know, in local parlance, they will say, Epo alowoyin, edeka la. You get something for her because share it. So in that instance, water has become a nuanced language. It has become a balance. It's become like something like slang, you know. There are other languages that you can use water for that I won't get into. So words have core meaning. They have general language. Like if you say white, white is a color. In fact, there is no human being on earth that is the color white. But what we don't know is that there is a game of superiority between race. So some people chose to call themselves white and called another set of people black. Until today, that statement that some people are black, nobody is black. I always contend. I remember when I was schooling in the US and somebody would say you are black. I said, no, so with all due respect, that is a language you use here. Me, I don't think of myself. At best, if you must describe me as a Nigerian or an African. With all due respect, I'm not black.
Sir, did you feel bad?
Why should you allow somebody to call you black when the person wants to call himself black? Why? It's a contrasting, derogative, pejorative, denigrating. Don't let me finish it's annoying. Nobody, have you ever seen anybody that is white? Check all those people who call themselves Caucasians. They are not white. Either they are a shade of brown, they are in the spectrum of human skin. The only people that are white are foxes and wild animals who change their something during snow. And those ones, they mimic the snow and become white. You know? So let's leave the color white. So bottom line of it is that once you say white, you can use it for race. You can use it for excellence. Oh, we said the thing is brilliantly white, which means that it's untainted, it's snow white, you know? So words can have core meaning and then general meaning and then nuanced meaning like balance, secret, and you have to watch it. You know, if you go and use words that mean something in a society, you can get in trouble. A typical example is when you talk about onions. Know how you use the word onions. It can get you into trouble, you know? Know your onions. So onion is edible food something in condiments. So I can say know your onions. Know your onions has to do with knowledge. But if I use onions in a slang, it relates to a body part, you know? So words can have core meaning, and that is when you talk about the literal and textual meaning of words. And if courts are determining those things, then they can say that these words are, And then in the textual and literal approach, there are other things that you do, use them generis, notio associates. So words, when the words are associated to each other, you give them the textual and literal meaning. But where words are not unambiguous and all that, then you go to the liberal meaning. When you're talking about liberal meaning, you are giving the words or the interpretation that allows for, a maximum interpretation of the words. So for instance, when you say he, in every legislation, they talk he. But most legislation will not do he, she. But in a liberal interpretation, he also means she. Also in a liberal interpretation, one also means many. Singular means plural. Okay? And oftentimes in liberal interpretation, a particular word is given the broadest meaning so that even a discretionary power is given a broad interpretation, as it was done in the case of Ibrahim against the states, where they said the Attorney General may, grant discretion of exercising nolle prosequi to prosecute to anybody. And of course, anybody meant anybody, because anybody, even though the Attorney General can be said to be irresponsible if he's giving it to anybody, but anybody means anybody. Now, the third school of thought, which we have in Nigeria, is what we call the purposive approach. The purposive approach, okay, it's an amalgam. While the liberal approach is like the golden rule, and the literal approach is like the textual rule, the purposive approach goes beyond the golden, the textual, to the mischief. What is it exactly? It looks at, and unlike the literal and liberal rule that are restricted exclusively to the provisions of the Constitution, the purposive approach allows for looking at other materials. So the purposive approach can look at the debates or the instruments that preceded the making of the Constitution. And Justice Visha Craig stated the purposive approach does. It says, the purposive approach takes account not only of the words of the legislation, that is the Constitution. Hello? The words of the Constitution according to their ordinary meaning, but also the context. What's the context in which the word is used? The context will not be limited to the language of the rest of the Constitution in the light they throw on the Constitution as a whole. The importance of the subject matter is not lost sight of. Equal weight will be given to the scope and purpose of the Constitution, as well as to the background. What took place? There will be no concentration on the context to the exclusion of the language. The grammatical usage of the word, the contextual sense of the word, the scope and purpose of the Constitution are all important. It is a process of synthesis. So a purposive approach is a process of synthesis. You look at, and this purposive approach was used in the Attorney General of Lagos State against the Attorney General of the Federation, when the court looked at urban and regional planning and looked at what preceded, in interpreting urban and regional planning vis-a-vis environment. They said, no, this environment has a meaning, urban and regional planning has a meaning. But historically in Nigeria, how have we done it? And using the historical approach, they were able to, to resolve the issue. A purposive approach was also used in Attorney General of Ondo State against Attorney General of the Federation. A constitutional document, when it was stated, a constitutional document must not only be given liberal and broad interpretation, it must also be construed without the usual technical inhibition of ordinary statutes. It is not the duty of the court to defeat the obvious ends of the Constitution. The court must construe the provisions of the Constitution in such a way as to justify the hope and aspiration of those who have made strenuous efforts to provide the Constitution for the purpose of good governance and welfare of the persons in the country. So having regard to the, it is necessary to observe that what has to be construed is the constitutional document, wherein all the provisions of the governance of the So we look at the Constitution in a purposive manner. You look at, and then in the Attorney General of Ondo State against Attorney General of the Federation, they looked at the provisions relating to corruption in order to determine who is better fitted to, make the law. The state argued that, look, the federal government has no jurisdiction because there is no exclusive legislative list mentioned. But the court was able to use the creation of institutions in the exclusive legislative list to say that, look, corruption affects Nigerians as Nigerians, not as Nigerians from Lagos State or from Ondo State or from this state or from that state. If you are a Nigerian and corruption affects you, it will affect you. And I tend to agree with the court. I remember a particular experience that validates this for me. I was a Fulbright scholar, and I was given a ticket that takes me from Lagos to Los Angeles, passing through Brazil, which is a very unusual route. And I now decided that, look, on my journey back, I want to break the journey and spend some days in Rio de Janeiro. And I applied for a visa to the embassy in Los Angeles to give me a visa and let me be able to go to and stop over in Brazil. Interestingly, at that time, I was working in an American law firm in Los Angeles. And I used the privilege of that to have a secretary in the law firm book an appointment for me for visa consideration. So it went very smoothly. Apparently, because of that law firm, they assumed that I was an American. And of course, while working in that environment, I had taken on an affectation of an American accent, which I discarded when I came to Nigeria. But of course, that was necessary in order to be able to meet the requirement of speaking clearly to the clients. So I spoke like an African American. So all through the conversation and all that, it was okay. Then came the visa consideration, which they give to you there and then. And then I brought out my Nigerian card, my Nigerian passport. I've never been so embarrassed in my life. And then they start speaking Portuguese. They go in to meet the Chade Diafia or whoever is the person. And the long and short of it, they just came with a notice announcing that my counter is closed. I'm the only one to be attended to by the counter. And they asked everybody else to get from my behind. And they moved them to another counter. And there I was waiting. And the person who came was so rude and told me, how can I dare to want to apply for visa here, knowing that I'm holding a Nigerian passport? And I said, why? Other people are holding. And there were people who had, other passports. There was no big deal. And then I said, don't I know that my country is one of 7 countries that are, that have very bad reputation for cocaine, for this, for that we don't take passport outside Lagos. I should go to Lagos to take the passport, to take the visa rather. And of course, I left the place with my tail between my leg, and I went to the law firm. Thankfully, they picked it up, and it became a diplomatic row. Because the law firm, made a lot of you and cry. And to cut the long story short, I was brought back to that same place, and those people lined up, apologized, and gave me a visa to travel. And in order to compensate, they now paid for the hotel, the food I would eat while in Rio, gave me all the spots I can visit in Rio. But psychologically, I have been damaged as a Nigerian holding the green passport. So if you look at such a subject matter as corruption, the Supreme Court ruled properly that corruption affects all of us. The only place I don't agree with them is that it should not, because prosecution of corruption should not be exclusive to the Supreme Court. And that's what we have done. When I was the Attorney General for Oyo State, we passed the Anti-Corruption In fact, we call it OYOKA, Oyo State Anti-Corruption Agency Law. So, So, corruption should not, but for purposes of our argument, we have to look at the origins of corruption, and Attorney General of Ondo State gave the federal government jurisdiction on corruption using the purposive approach. In the recent local government decision, the purposive approach was used to even change provisions of the Constitution, to the extent that now the court is of the opinion that direct allocation can be made from local government to the state government, from the federal government to the state government. Of course, that has been criticized. It has run into trouble. Purposive approach has to be used in a way that does not sabotage also the intendment and purpose of the Constitution. So these are the three major constitutional approach that is used in Nigeria: the textual and literal approach, the liberal and broad approach, and the purposive approach. Any question? Any question?
Excuse me, sir. Good afternoon,
Yeah.
sir. I want to ask, in the case of Ajilo versus Savannah Bank,
Yes.
which approach was used, sir? I feel it's opposite approach.
In the case of who? Which one?
Ajilo Bank. Sorry, Savannah Bank versus Ajilo. No, Ajilo versus Savannah Bank. Yes, sir, versus Savannah Bank.
On the jurisdiction of the Federal High Court and the State High Courts. Yeah, it can be argued that they use a purposive approach, but it's more of a liberal, broad approach than a purposive approach, because in that case, the court tended to use a liberal and broad interpretation to reach what he wanted to do.
Yes, sir. Thank you, sir.
You're welcome.
Stop the differences between liberal and purposeful approaches.
Yes, the first thing you need to know about the liberal and the purposive approach is that the liberal approach is focused on the provisions of the Constitution. It doesn't go outside the provisions of the Constitution, but the purposive approach does. It goes outside the provisions of the Constitution. It looks at documents that, so for instance, under the purposive approach, we can look at the Constituent Assembly, debate. We can look at the CDC debate to know what exactly was in the minds of the drafters of the Constitution. And in America, the purposive approach is even used when you talk about framers' intent. What was the framers' intent? For instance, in Roe v. Wade, the court used a framers' intent, which we call purposive approach. And the framers' intent was used because if you look at Roe v. Wade, for instance, as at the time when the Constitution was written, it was a crime to even do abortion. But as at the time when it was being interpreted, it was no longer a crime. So they said, what was the framers' intent? The framers' intent is to protect the unborn child and also to recognize the right of the woman. So using a framers' intent, which we call purposive approach, we can then say, okay, at this particular time, the child is using a purposive approach of inviting medical opinion. You can say, at a particular time, this child has formed, and as a result of that, it should be a crime to abort the child. And that's the second trimester. But before the second trimester, this trimester thing is not in the Constitution. It was taken outside the Constitution to reach a solution in determining the rights of the people. And that is why the present Supreme Court have said, look, all that trimester and all those things, they are not. And since they rejected that approach and they have gone to the literal and liberal approach, and they have gone to criminalizing it and all that. So a school of thought can come and hold, another panel of judges can come much later and hold differently depending on whichever theory they are using. So the basic difference between the purposive and the liberal approach, the major one is that the liberal stays within the constitutional provisions, but the purposive approach goes outside the constitutional provisions.
Thank you, sir. So
Yeah.
the way that I see the purposive approach, like it looks like it adopts like other approaches, like the mischief or historical approach.
It incorporates all those contextual, what's the history, what's the historical, what's the background. The purposive approach, that's why it goes outside just the mere provisions of the Constitution. It looks at context. So the context can be cultural, can be historical, can be economic, can be political, can be, So that's what Attorney General of Ondo State against Attorney General of Federation and Attorney General of Lagos State and Attorney General of the Federation in urban and regional planning, that's what they represent. Yeah. Any other question?
So I have a question.
Okay, go ahead.
When you said that liberal approach does not really go away from the Constitution, but in Ajilo versus Savannah Bank, in that case, the Land Use Act was stated there.
Yeah, because the Land Use Act is part of the Constitution, so it didn't go outside the Constitution.
Yes, sir. Thank you, sir.
Yeah. Any other question? For the avoidance of doubt, in the Ajilo, the Land Use Act, you notice that the Land Use Act is made part of the Constitution. Okay? And then earlier cases like Nkocha's case have stated that the Land Use Act has constitutional flavor because it is contained in the Constitution. So it is still a liberal approach when you interpret the Land Use Act, because the Land Use Act has now been made a part of the Constitution. Even though you may want to argue that going to the Land Use Act as an act gives it a purposive approach, but the truth of the matter is that in this instance, the Land Use Act was a provision in the Constitution, and because the Constitution made it a constitutional provision, it makes it a liberal or broad interpretation of the Constitution.
Sir, forgive me, sir. But please, sir, can you run over liberal approach again?
The liberal approach will normally be where the text, where you are not using a textual or literal meaning, where you are now looking at the Constitution, other provisions together. You are looking at how you can interpret these provisions to give effect to the intendment of the Constitution. So that's why we said it's a liberal approach. So in a liberal approach, there will be several interpretations given to the Constitution. Literal one, textual one, and then the court will say, no, textual and literal will not work. Let's use a more liberal approach that goes beyond just the text and the language of the Constitution.
Yes, sir. Good evening, sir.
Good evening. Good afternoon.
Sir, please, a lot of people in this class have another class right now, sir.
What did you say?
A lot of people in this class have another class by 3:30, sir.
Yes. I just wanted to take all your questions because this is actually my last class with you. So by the next class, another lecturer will be taking you. I wish you the very best.
Yes, sir. Thank you, sir. Thank you for your time, sir.
Thank you, sir.
Bye.
Thank you,
Thank
sir.
you, sir.
God bless you, sir. Thank you very
Thank you
much.
very much. God bless you too. All the
We
best.
love you.
Thank you,
We
sir.
love you
Sir.
too.
Yes, we love you,
Merry
sir.
Christmas.
Thank you,
Happy
sir.
Merry Christmas.
Compliment of the season, sir.
Same to you. Enjoy your Christmas.
Compliments, sir. We really
Thank
enjoyed
you.
your
Yeah.
God
class,
bless
sir.
you, sir. Thank you so much for all that you do.
Well, one of these
You are
days,
welcome. You are
we
welcome.
get to see one on one. God bless.
You are
Yeah.
welcome.
Thank you,
Bye.
sir. We are looking forward to
Bye.
seeing you one on one, sir.
Okay.